tell me not in public, not here today, let me know, all right? So, today, more tips for better practice in trial court. You guys, again, give me, tips. Obviously, you got some, things we talked about with Chancellor. On the security issue, I'll just give you a quick rundown in my court. The 28th Judicial District, for whatever reason, Chancellor Ellis, before I got there, refused to do orders of protection. You guys all been talking about protection. Well, I get there, and the clerk came back to my office one day and said, Chancellor Mansfield, we've got a petition and order of protection up here. What do we do? Well, do I have jurisdiction to hear it? They said, yes. I said, well, why are you asking? They said, I said, well, Chancellor Ellis never did it. I said, how do you get away with that? He said he wouldn't do it. I said, okay, go ahead and run file. About 2 or 3 weeks after that, my court officer comes in while I'm talking with my assistant and my court clerk, and he walks in and says, are all y'all packing? And Kim Norman, my assistant, told me, she said, that's the day I knew the temperature changed in this room when our court officer came back here and asked us all if we had. So anyway, we were very attuned to courtroom security when each district. But there are numerous weapons floating around. Anybody needs one. So, all right. So, more tips for better practice in trial court. Like Chancellor Mansfield, I was doing this yesterday afternoon. I had to go to last night. So, I haven't to rehearse this. Don't know how long it's going to take before we get started. All right, and let's see what we got. You guys see this over the top of our benches, right? The judicial seal. Does anybody know what the motto means? Vita, Justitia, Villa, Colia. You never thought about that? So I go to a judicial conference and I'm sitting there thinking, I'm a judge now, that's my secret. All right, what am I telling people when I do that? Now, next slide. Now, not the Onion. You guys know the Onion website? Okay. What it says is, you better go read it. Let justice be done, though the heavens fall. You guys think that the judiciary makes such thing? I don't know that I did when I was practicing, and I'm not sure that we do now, but that's the motto of the judicial system. Let justice be done, though the heavens fall. And so I do try to meet that standard. I mean, believe it or not, I get it, I see the greens, but I try to uphold that standard. All right, go ahead. So who is this guy? You know, I'm the new chancellor. I got sworn in September 1st, 2022, right? Go ahead. Does anybody know what that means? All right, so this is on an intellectual level. This is 2 weeks ago, okay? I had a doctor's appointment. My wife and I went to Cracker Barrel. And I don't know if all of you have been to Cracker Barrel and played the jump all but one game, right? Ever done that? All right, so I'm going to start by so what it is, jump each one and remove it. Now, leave 4, and you're just playing ignoramus, right? Leave 3, you're just plain dumb. Leave 2, you're pretty smart. But look at leave only 1. I had a witness, my wife's son. He's a genius. That's what we're talking about today. That is my genius measure. That's where we're at. This whole presentation is going to be on that level. The left one on the jump. All right, go ahead. Will the video work? Do you know? Let's see. I'm going to give you guys behind the scenes a little bit. If it'll play, I don't know.
It is. Try one more thing.
Play on that. There we
Maybe.
go. There we go. Quick behind the scenes from Carol Burnett.
There we go.
Go to 201. Maybe scroll up.
Mrs. Hubrigan said, the reason I brought you in here now is because I have report in the meeting today with Mr. Phillips. He's going to be here at the noon. Mrs. Hubrigan said, do you have any idea of what I'm saying?
Yeah, I think so.
That's close enough. Now, I want to run over 2 very important parts with you here because of this meeting. Now, first of all, I don't want any anybody into this office here before noon. Do you understand that? Yeah. All right. Now, point two, there's some things in this contract here that are a little. You run over those together, just in case this time it's.
If you guys want to know what goes on before 9, before the door opens, you just got a brief glimpse of the morning. Kim's great, all you know she is. We got a great time. She keeps the show running. All right, let's go to the next slide. All right, let's talk about the law. Chancellor Mansfield touched on this. Notice in ex parte TRO receipts. I understand. I have actually been told that I have a reputation that I don't like ex parte TRO. I don't know how that got started. But I've been told that lawyer came in my office and said, Chancellor, I know you don't like ex parte TROs. I said, no, bring it. I enjoy reading your paperwork, being in my office, drinking coffee, all that kind of thing. So the part B is where that came from. Because Chancellor Maroney, and I got this from him, so blame him for what I'm doing here. The applicant's attorney, pro se applicant, certifies in writing efforts made to give notice of the reasons why it should not be required. Again, the Chancellor, just like Chancellor Maroney, that's a simple requirement. We don't need any kind of flowery language or anything like that. But I'll tell you where I'm coming from. And I've had 2 experiences with this so far in last year. I don't get many ex parte TROs. You guys do a great job of keeping everything above board and getting everybody there. But I do understand that sometimes your clients think that it's an emergency and it's got to be done, and your clients really want to do it without anybody being on the other side. They think it's easier if the other side doesn't show up. And maybe it is easier to get an order, okay? Maybe they win, maybe they will win. But when you do that, the undoing of an ex parte TRO, if it was improperly granted, is very difficult. Okay, so that's what I'm trying to avoid when I enforce this section. I want to know what makes this case such an emergency that you can't pick up the phone or text or Facebook message or do something to the other side and say, hey, I'm approaching the Chancellor at 8:00 a.m. next Tuesday or this coming Tuesday to ask for a TRO list. In these days of all kinds of communication, because this doesn't say my service was wet or the attempts at service. This is attempts at notification. Okay, text message, phone call. Everybody's got a cell phone. Everybody's on Facebook. So there's a lot of ways to tell people, hey, I'm going to court in 3 days. Show up if you want to be there, or show up tomorrow afternoon, or whatever. I know there's lawyers in this room who, after I denied a TRO on this basis, 2 days later, their lawyer, the other side's lawyer, is saying in court, we worked it out and got the result we should have. And I've been burned once when I entered an ex parte TRO, and a lady ended up in jail over it, and it was improperly granted. So it's a big deal, and I understand, I realize there are actual real situations where you cannot give your client notice of something. Whether they're a flight risk or something to that effect, I get it. Those are going to be extremely, extremely rare most of the time, and it's just better. I understand though that you lawyers can tell your clients, hey, I'm not going to ask for emergency relief because this isn't really an emergency, and if you get the other side here, we can probably work this out. They don't want to hear that. They want to hear that I'm going to get that order, and we're going to. The other side's not going to be here. We're going to take the kids away this weekend, and they'll be at your house. They want to hear that. Well, tell them that, and then tell them the mean old crazy judge what to go along with. I know what my role is, okay? I get it. I don't mind being a scapegoat. That's what I get paid for. So go ahead and bring them. But when they get denied, based on this basis, I'm not doing it just because it's in the rule. Okay, there is a reason why I'm avoiding those efforts, because you get a better result with the other side. You just do. And then we're gonna have to undo something if we got the wrong. All right.
Could I ask a question at that?
Yes, ma'am.
Are you talking about notifying the other lawyer if there's a lawyer on the other side, or if this is in an initial filing, actually calling the defendant and saying, I'm the lawyer and I'm going to go see the judge in 3 days?
Both.
Okay.
Because sometimes what'll happen, and this has happened, you call that defendant and say, hey, I'm going to see see the court tomorrow, I'll be there at 11 o'clock, because the judge can hear me tomorrow at 11 on this, TRO. If you want to be there, you can be there. They'll get on the phone and call a lawyer. And instead of this defendant showing up, you have a lawyer on the other side that gets things kicked off, and that's where the process gets worked out like it should be. Now, sometimes you'll call the defendant, and that's what I'm saying. If you're the lawyer, call the defendant, your client or whoever, say, hey, I'm going, call my office at a time when I'm going to be available in the office or on the bench. Get a time and say, okay, I can be there tomorrow afternoon or, two mornings from now or something. Call the defendant. And they'll either have a lawyer there, or they won't show up, they may show up. I don't know. But yes, I'm talking about lawyers and defendants. I won't be party. Yes. Well, that's the other part of the rule. Read it carefully. It's the efforts made to give notice or why the notice should be waived. If you put in writing what you just said, I'm not making a advisory ruling. Okay, this is not a ruling. But I'm going to say, depending on the other, the sworn declarations in that pleading, because to back up what you just said, it's got to be sworn under oath. All right, but I will tell you, that's almost the exact scenario where I improvidently granted a TRO, a lady ended up in jail for 7 days without her kids, and then I resolved. So be careful and make sure that your compliance, if you're going to write that down and say that the lawyer is going to assert that this kid is about to go to California and we can't give notice, it's an emergency, we got to get it done. If you're going to write that, you better have your client review that pleading. If they don't speak English, get an interpreter and have it read to them in your presence and have them sign their oath and swear an oath that that's all true and accurate, so it gets you off. So that's the second part of 65.03. I mean, you don't have to give notice because there are situations just like you're talking about that you need to get to court. And that's why I don't went out that I dislike ex parte TROs. There are reasons for it, and I understand it. I'm not trying to get rid of a TRO. I'm just trying to do it in a manner that prevents them from being improperly granted, screwing up this family's world, and then it's having to try to put it back. Yes, ma'am.
I don't understand how somebody ended up in jail, for violating a temporary restraining order.
It's a long story.
Okay, well, I mean.
And one of the lawyers is in the room, he'll catch you after the hearing, or
Okay.
both the lawyers are in the room.
Okay.
They'll catch you here in a little while, be in there.
All right.
I don't even talk about it.
Okay.
Still can't.
All right.
Anyway, you want to hear the rest of the story.
I do.
All right, so what are we on now? Service by publication. Okay, here's another one. It's similar to the ex parte TRO thing. It's a notice issue, okay? Under the statute, so the rule says that in case the work constructive service process is allowed by statute or other law, and you get it, that's what Rule 408 says. So the Chancery Publication Statute, 21-1203. And so, 85 says when the residence of the defendant is unknown and cannot be ascertained on diligent inquiry. That is like the 65.03B that we're talking about, the on diligent inquiry. Now, I've had lawyers and I've sent them out. They come in and they say, hey, Judge, we tried to serve this guy, we got it back, and we need to do certified publication. My question is, okay, what kind of diligent inquiry have you performed to try to find the guy? Well, we sent the sheriff out. Have you looked at Facebook? Have you texted his cell number that your client knows? Have you called his brother-in-law or whatever? Well, no, we sent the sheriff. I'm not going to grant publication in that situation. And I have found, or the lawyers have found, through not much effort, in 2 cases, they found that they got them served, did everything everything done correctly, the case has got resolved, and so that's why I want you all to understand that I'm not enforcing these rules just because they're written. There's a reason for them, and I'm trying to get the spirit of the rule by enforcing the language of the rule. So if you want a service by publication, put in a pleading the efforts that you made to locate this person. And sometimes, you know, diligent inquiry may just be Facebook or it may be text or something, but you know, there's a lot of services out there. Lexus, Nexus, Westlaw, they have people locator services. You know, there's different ways to at least give some minimum effort. I am not going to require, I'm not giving advice or opinion, but I'm most likely not going to require you to hire a private investigator to go track the guy down or go track the girl. But I do expect you to text their cell number if your client has it. Yeah. All right, next slide. Let's see. Have you guys ever heard of this? I don't know if anybody's ever used it, but I just thought it was interesting. So 37-1103, it talks about the exclusive jurisdiction of juvenile courts and defense and neglect cases, things like that. This case, the juvenile court has exclusive jurisdiction. The part G says, notwithstanding all that stuff that you just said, nothing in subdivision A1, which is the exclusive jurisdiction part, shall be construed or precluded for exercising domestic relations jurisdiction pursuant to Title 36. So if there's some action under Title 36 of the Domestic Relations Code, even if it involves something that the juvenile court would otherwise have exclusive jurisdiction on, you can file it in chancery. Maybe in circuit, I don't know. And it'll stay there, and that judge or that court has jurisdiction over that case until someone objects or somehow files a pleading in the juvenile court to invoke the juvenile court's exclusive jurisdiction. I'm not advocating for more cases being filed in chancery court, but I thought that was interesting, so I wanted to at least point it out and ask you guys, am I interpreting that incorrectly, or is that y'all's understanding?
That's right.
Okay. All right, well, we do. But I do appreciate your business. I really do. I appreciate you guys coming to my court. I'm very busy. I want you guys to understand it's duck season, okay? December, January, okay? So if you guys want to take some vacation time, I'm good. I'll give you a day. Let's do things in the afternoon, all right? I looked at my calendar, I'm going to talk to Kim Monday. I said we're going to do things in the afternoon. All right, so go ahead. Okay. All right, civil versus criminal contempt. And this is a lot of business. Civil versus criminal. Oftentimes they're included in the same pleading. You know, people are making a choice when they get to court, and that's fine. All of it's good. But be aware, and I know all of you are aware, if you are seeking criminal contempt sanctions against someone, you have to give them the notices and Rule 42 of the Rules of Criminal Procedure. They have a right to counsel, they have a right to remain silent, they may go to jail, be punished, all that kind of thing. So you got to meet those minimum requirements of notice of what their constitutional rights are because you're pursuing a criminal sanction. So, you know, obviously the criminal statutes, number one, require that notice. Number two, is to punish conduct that can't be rectified by putting someone in jail and handing the keys to jail. It's to punish conduct that's already happened that can't be put back together. Now, one thing about criminal contempt is you can't get an award of attorney's fees if you pursue a criminal contempt action, all right? So my next slide, and this is just Rule 42. Go ahead. I had a case once, and I think the lawyer who I did this ruling is in the room, and I'm not sure if it gets appealed. I don't know what'll happen if it gets appealed, and I don't know if this is even right. So this is kind of me learning from you guys, okay? Tennessee Code Annotated 29-9105. If the contempt consists in the performance of a forbidden act, the person may be in prison until the act is rectified, placing matters in person status quo. Okay, that's the civil contempt we're all used to, right? Put them in jail until they rectify the matter, or by the payment of damages. Y'all ever read that? Ever read any cases that say you can rectify a civil contempt by the payment of actual compensatory damages instead of throwing somebody in jail? Anybody? Somebody raise their hand. Tell me I'm not down on the thing here. Well, I resolved the case, and this statute seems to fit a lot of the civil and criminal contempt actions that I get. Somebody was pursuing civil contempt, but everything that they put on proof about had already happened and couldn't be put back together. So I'm like, how in the world am I gonna rule on this? So when I get confused, I do this all the time. My clerks make fun of me for pulling those green books off the shelf. So I pull off the index and start looking at contempt, find the contempt statutes and start reading them, and I said, well, 499105 and a couple of cases from 1892 interpreted them say that I can pay money damages in civil contempt. And guess what? I can also award attorney's fees. And so you know what? That's what it is. I don't know. That's what the ruling was. What do you guys think? Did I get it right? Did I get it wrong?
Well, right, because that's child support.
Was that?
Civil contempt for child support is payment of damages plus attorney fees. You're right.
So I don't know if I opened Pandora's box for you guys, but this seems to be a much easier remedy than pursuing criminal contempt. For example, burning somebody's clothes in the garbage can. Yes, sir, Chancellor.
Criminal contempt also has a different standard of proof beyond a reasonable doubt as opposed to civil, which is violence.
Right.
It's easier to get from the civil.
It's just an easier case all the way around. And, you know, these people, like I said, they're burning their clothes in the garbage can, they're throwing stuff on the street, and, you know, something got wet, or I don't know. And the people that are pursuing the criminal contempt, they're mad when it happens. They come to you and they want you to punish somebody, punish the spouse for doing whatever to them, or, you know, breaking that Jimmy's vase or something like that. You can't put it back together. And they're mad and you want to get paid and they want to pay you to file that motion of criminal contempt. And you're going to go to jail and all that kind of thing. But by the time you get to the hearing, they don't really care about it Jimmy's vase anymore. They got bigger problems. You know, they're trying to run 2 households now out of their same income. Their kids are going back and forth. They can care less about sitting there next to you in court in front of me, getting up there and saying, hey, I want you to throw her in jail for 10 days because she broke the vase, or she burned my workshop, or whatever. You know what I mean? They don't even want it by the time they get there. But this kind of thing, though, is civil contempt. You ain't got to worry about all that. It's easy to get a hearing date because you don't have to give them notice. You get them there, you put on the proof, the standard of proof is lower, you know, and then it's payment of damages instead of somebody going to jail. Because a lot of times, by the time they get there, they really don't want the other spouse going to jail because the other spouse still has a job and is contributing to this whole mess. At least they're contributing some money into it. They get fired, get thrown in jail because this crazy judge went along with you and gave you what you really didn't want. And your other spouse is in jail, you cut your income in half, you got to get the kids there, all that kind of thing. So I don't know if this is right or not, but I do suggest that you guys look at the statute. 499105, and you can know that in the 28th judicial district, it has been enforced at least once. I've done it. Now, maybe the test case gets overturned in the Court of Appeals, but I think this is a much simpler and much more aligned with reality and remedy than trying to pursue criminal contempt. All right, Andrew. Let's say motion to alter or amend. Thank you. Some of you last year, I stood up here and I said, look, I'm brand new at this. If I get it wrong, please file a motion to alter or amend so I can try to fix it before you go on the paper. And thank you for some of you taking me up on my offer. And really, I do learn from those things, okay? Because I'm still learning family law. If I miss, you know, the simple stuff, you know, that I'm supposed, there's some statutory requirement and this kind of alimony or that kind of alimony or something, I'll miss it. I don't know. So if I screw something up, please file a motion to alter and then try to get my order correct. If it gets appealed, then at least I look like I know what I was talking about. You know this. All right, I don't mind getting that at all. So that's just the rules being cited 5202 and the next slide forward. So under either or both of those rules, 52 is to ask me to make additional findings of fact, things like that. This is for me to just alter amended judgments. Please take advantage of that now. Just like I said last year, I'm not gonna sit and look at it like an appellate judge and change my mind. Don't try to change my mind with a Rule 59 motion. You do that, you're just laying all this kind of thing, but if I miss something, and judge, you can't do this, or this is an illegal ruling, or I forgot to do something about a quadro. I don't know what a quadro is, so tell me, if I miss it, put it in this motion, we'll figure it out. Right, go ahead. All right, did you guys, and you sent all these materials out by email, right?
All I got was the palette.
All you got was PowerPoint. Okay, well, after this is over, I'm gonna send you guys, Judge Mark Johnson, you can sent me a 9-page termination of real rights summary sheet. I have not read it and applied it very much. The next time I have a termination case, I pull out Judge Johnson's summary sheet, and I will probably be using that. I will give it to you, so you'll know what the judge is going to start with. I don't know if that's the do all, end all. It's 9 pages and some kind of summary. I think he may have got it at the judicial conference at some point. It looks really good, and then all this termination stuff, it's like Chancellor Mansfield said, all this termination stuff, it's very complicated. It's very factual, finding intensive. It takes a lot of work, and so if you guys want to see what I'm kind of using as a cheat sheet, I'm trying to send it to you. So Andy, I will get that to you after this conference, so you can send that to her. So I behoove you that you have termination days. Take a look at that at least at some point. All right, motion to propel. Now this is our local rules. I threatened last year that I was going to revise our local rules. I'm probably 2/3 of the way through it. I also told you all that I was going to have electronic filing done. I've got the contracts written. I'm still getting my rules tweaked. Hopefully by the end of the year, I have that submitted to the AOC. That's my goal. And then maybe early next year, we'll get electronic filing for the expedition. I've still got to get the electronic payment system set up in Crockett County. They don't have a method to take electronic payments right now. Other 3 court clerks, Humboldt, Trenton, and Brownsville, they all have electronic payments set. And I have the contracts for the vendor. I just got to get the rule finalized and sent up to the AOC. Because some of the rules, electronic filing rules I look at, I do like. A couple of them I don't like. There's some provisions I need to change. I don't know if I have the authority to do that. But anyway, this is our current local rule 13G. And the next local rule will be substantially similar to this. I don't dispute it verbatim. Each motion of the government should be accompanied by a certificate of legal authority that after consultation between parties that are unable to reach a court or taken unsuccessfully to initiate a conference with opposing counsel to resolve the discovery dispute. So you got to put in the motion or in the accompanying certificate that you have tried to get with the other counsel to resolve the dispute. A letter will work. You will copy. I previously wanted to require a telephone conference or an attempted phone conference, and I recommend that. Okay, this discovery stuff. Send somebody a letter outlining your problems and issues, but then try to set a telephone conference with them. That's my preference. But I will accept the letter if you send out and say, your discovery responses are overviewed. And, please respond within 10 days of this letter, or we'll file a motion to compel. So if you don't have any responses at all, a letter's fine. If you think the responses are deficient, then I need something in writing showing that you pointed out the deficiencies. I want something you on the other side saying, this is the problem with it. Fix this within 10 days, and we'll file a motion. Again, I would prefer a telephone or a Zoom conference for that. I'm not going to require it. But I have told my clerks, if you get a motion to become discovery, it's not something in the motion itself or in the company certificate that shows that you attempted to resolve that motion before you file it. They are not to give you a hearing date until they get that. Whether it gets enforced or not, I don't know. Some of them come up and I have a certificate. I'm working on it, but that's my goal, is that you don't get a hearing date and the clerk say, hey, we're not going to give you a hearing date if you haven't certified that you try to work this out. I'm not trying to be a bear on that, but a lot of times discovery disputes can get worked out. And I don't mind hearing motions today. I really don't. But it's better if you guys can reach an agreement rather than having me impose something. If you got to get to court, get a hearing date and then wait on me or wait on the other lawyer to get the order done, and then you got to get filed and enforced and all that kind of stuff. When a lot of times a phone call will cut through all that. I understand sometimes you guys don't like one another, you know. You just make up and bite your tongue for just a minute and call somebody and say, hey, I sent you this letter, what are we gonna do about this discovery? If they hang up on you, that's their fault, they're coming to court, right? But you at least try and then certify in writing the evidence that you did try. All right, exhibits. This came up, file, I have to look in our exhibit policy, because a couple of the exhibits were very racist. They weren't very, they weren't fun to look at, but they were racist, okay? It involved some in-house camera footage and like, but anyway, so the current local rule and what the next local rule will incorporate or something like this, all exhibits from presentation course should be marked and warehoused, that is not my language. By the clerk and master, any all exhibits that originated, whatever, you read all that. So, in my court, we keep the original exhibits in the file. The next local rule is going to say that, and I probably won't implement this anyway before I even get it, that we'll keep them in the file for 30 days after the case becomes final. All right, so if it gets appealed, they stay in the file for 30 days after the appeal's over. If the order becomes final, we'll keep them for 30 days after that. Then the clerk will send you guys a letter, both lawyers, and say, the clerk and master is about to destroy these exhibits, either party can come get them. Right. So that's the policy I'm trying to get worked in now as far as exhibits, so it doesn't overburden our file any longer than necessary. So that's the policy. The policy now is the court clerk keeps them, and I'm going to try to get them worked into where they send the 30-day letter after the final order, whether it's an appellate order, whether it's a final order, whatever. Letter goes out 30 days. 30 days after that date of that letter, they will be destroyed if nobody has contacted the court. Kind of like the Court of Appeals does. You guys go to the Court of Appeals. When the Court of Appeals finishes in the file, they send a similar letter. Y'all familiar with that? All right, anything else like?
I'm sorry, I have to ask another question.
Yes, ma'am. And no, do not be sorry about asking questions. I don't know how long this is going to go, and so I've not done any of this, but I'm fine with doing whatever.
On marking the exhibits, Chancellor Ellis had the clerk and master actually mark them in court as opposed to the court reporter. And I think you have not been doing that.
True.
And so that was the rule that said the clerk and master would mark them, just so.
You know, that part of the rules I get before.
Okay.
Yeah, I'm not doing that. So, I didn't know how much time this is, so one of the last slides, if we need to fill up some time, is just various things about evidence and all. One thing is handling exhibits in court, okay? When you're handling exhibits in court, you don't have to bring me or give me a copy. I mean, it's great when you do it, okay? But don't think that if the other side handed the judge a copy and I didn't hand the judge a copy, that you somehow had a disadvantage, okay? What happens is, I write on my exhibits, you know, hearing day, exhibit 1, but if it's in my handwriting, that's the judge's copy. The official copy is the one that court reporter puts their sticker on. I do not want my clerk handing stickers and exhibits and all this kind of thing. I don't know why in the world I do that, but whatever. That's not happening in my court. It's like regular court, where you hand the exhibit to the court reporter, they put it, that's the official evidentiary exhibit. Now, if I've got a copy, the one thing that is helpful, if somebody hands me a copy, the only real, I guess, advantage to it is that I will make notes on my copy sometimes. I will write on my copy, I will never write on the actual evidentiary exhibit. All right, so again, it doesn't matter because I can write notes in my notebook just as easy as I can on the exhibit, but it's just more helpful for this actual document, right? So then when the trial's over, I go back to Mrs. Wiggins' office and I say, Kim, please scan this in. Scan these in as judge's copy of the exhibits and these in as the original exhibits, and then I don't look at the paper anymore. So that's where they go. There's the mystery of where all these exhibits and all these papers go. And so then my copy, after they get scanned, goes in the shred box, unless I've got a note on it, then I'll keep it. But well, actually, I won't. It's already scanned in. But if I know I've written a note on something, it'll be scanned in. So the judge's copy goes in the Fred box. It's on my computer. The original go in the file with also a computer copy or electronic copy of those. All right, now, as far as that goes, my notes are not for public inspection. All right, Chancellor Ellis, I understand, used to use something called docket sheets. Some of you guys that practice in front of him probably are familiar with docket sheets, where if he got handwritten on that docket sheet and put it in the front of the file, then that's what happened. Then that what really happened or not, that's what happened. We don't do docket sheets anymore. I write notes. I write so many notes, I've got tendonitis in my right arm. Okay, talk with it. I've got a strap for that, so better. But I don't use docket sheets. But it was always strange to me. They said, well, yeah, these docket sheets are in the file, but Chancellor Ellis won't let anybody take a picture of them. If you want to look at them, you got to come to court, stand at the counter and copy them off and all this kind of thing. I never understood that. But if it's in my file, which is what we're about to get to in a minute, it's a public record. I don't understand why a copy couldn't leave. But if it's in my file, it is not a public record. By statute. My personal notes and whatever you hand to me, I'm not going to hand it back. So whenever, be aware of that. When I ask you guys to draft an order, it's going to be up to you to make sure you have your notes right. And I don't mind sitting there and talking to you as long as I need to make sure that we're all on the same page. But I'm not going to send you a copy of my handwritten notes. For several reasons. One, by statute, I don't have to. Number two, I just don't want to. Number three, there is no way any of you can read it. I promise. It's just useless. It would be. I was in a deposition once. This was years ago. My client was an elderly gentleman. He's probably 75, he's probably 80 years old. He's sitting there and I'm taking notes, you know, screwing together, updating the adjuster, right? We took a break and he kind of nudged me. He said, you know, that's pretty good how you do that. I think they can do that kind of thing like you do. So I said, that's your name. I said, man, that's how I write. That's so anyway, that's the third reason we did that.
But there won't be a docket sheet?
What's that?
There will not be a docket sheet?
There will not be a docket sheet.
Well, let me tell you how it worked out on one of Chancellor Butler's docket sheets, which are also pretty close to my real one. This was a case that had been going, well, really, we go to Sherry Cole and say, what is this for? But we had a case that had been going on a long time with a husband who just wouldn't give us the information on his retirement. And Chancellor Butler had granted a default, and and so we had been to court, I think, either 3 or 4 times, and then he hires an attorney. And I kept saying, I've already got a default. We've got a ruling on everything except this retirement. And so the other attorney went and got the docket sheet, and clearly he had written in the date and what had happened, and the date and what had happened. And it said mother's parenting plan is approved and the whole bit. And it was clear. And then each time we showed up to have him come in and he didn't bring the retirement, it was on there. Otherwise, we would have had to go and get the court reporter to transcribe that and cost more money. And my client, frankly, didn't have the money to do that. So just so you know, I mean, they are helpful from time to time, and it was keep Madison County, so we didn't have any trouble getting the copy.
To put your mind at ease, all right, I have all my notes. They're all scanned in electronic. I have them. I have access to them, and I'll throw away the actual original notes. I have all my notes from all these cases and hearings that we have. And so, if there's an issue that comes up, hey Judge, you ruled on this, but we can't agree on what the order is, and we can't remember what it is. Set it for a status conference. Okay. Set it for a hearing, and I will look at my notes and do my best to interpret. Usually, I've only got a 2-week window where I can read them. But yes, just set a status conference, telephone, in court, whatever, and say we don't remember. I'll go look at my notes and I'll read it to you. But they're still there. It's kind of a different procedure. I'm going to add an extra layer of complexity to my code. That's above is direct to the source of the written. I'm not. It's more complex. Yeah. Again, I don't understand.
Yeah,
I don't know explanation, but that's fine, you know, everybody's got their ways of doing things, obviously, I think, you know, you guys can see what Chancellor Maroney's put up, he's got a different way to do things over here tonight, I don't do anything. File your case, it's still sitting there a year later, we'll send you a notice, I'm gonna dismiss it. You say don't dismiss it, I'm gonna ask you why not, you don't respond to it, I'm gonna dismiss it. That's pretty much the way I handle my docket stuff. Now, I do understand in termination cases, I have a statutory duty to set a hearing within 6 months. I do understand that almost never happens for whatever reason, and so I will enter an order extending those time periods. I hate it for the kids, I really do, but it's not my document management problem. It's the party's problem. And I don't take on other people's problems really well, you know? I just do my thing. You got a problem, your case gets dismissed, your client's mad, whatever, that's your part. So I'm not gonna take it on, now, I don't mind issuing scheduling orders. I like scheduling orders, they're fine. But typically scheduling orders are valid, or only honored in breach. And so I'm not gonna enter them in every case, because it's just gonna keep going. You guys do your discovery, do your stuff, get your hearing date, 10 moments, I'll wake up for business, I will give you the time, and I'll get on the bench, and I'll do it, we'll start early, we'll do whatever we need to do, but I'm not gonna bother you for a year. At the end of the year, I'm gonna send you a show cause order, you haven't done anything, you don't respond, your case gets dismissed without prejudice. If you write me a letter and say, Judge, we've taken 20 depositions, and we've got 5 more to go, and then you extend it, put you back on for another year, let you do your thing, and we'll see what happens. Until y'all finally get tired of messing with our business. So, let's see. I can't remember if this rule, yeah, that's the upcoming rule. You see what I've kind of got drafted right now. I haven't put this out for public consumption except for right now. After a judgment becomes final, the parties have 30 days to extend the exhibits. After 30 days, that becomes final, the parking master shall notify the parties that it's short of 30 more days. So actually, I deviate is 60 plus or something. So it's not like we're going away anytime soon. All right, give it a new slide. So this is where we get back to my racing exhibits, okay? So the exhibits go into the court file. My court file is a public record. Okay? So anybody else, you know, if somebody's got some racing stuff, if you got some public figures involved in this, or unless you get it filed under seal, any exhibits you put in at trial are going in my record, and the newspaper, or the other party, or whoever, or whatever, the kids, or uncle, whoever, can go and get a copy of whatever exhibits you put in my file. And they're gonna remain there until, you know, after the case becomes final. So, and this is the current public records policy for the 20th district. We do actually have one that mirrors the TPRA, Tennessee Public Records Act. So there's like I can't remember if it's CTAS or MTAS or somebody, they have a model public records policy. That's essentially what ours is. It's just this one for Humboldt. It actually says, clerk and master Gibson County. I'm gonna revise that to make it the 28th judicial district, but all of us follow the same thing. They're all presumed to be open for inspection unless otherwise provided by law. So if you get your documents filed, they're sealed, they're open for inspection, and otherwise provided by law, one of the circumstances, orders of protection. In orders of protection cases, I do not send out the exhibits. I do not send out the confidential statistical information sheet. Under the statute, the public record statute, the only thing in order of protection cases I send out are the actual Supreme Court forms, the petition, but those will have the home addresses of the parties redacted. So you're not gonna get those salacious exhibits, and of course, protection, and many of them are very salacious. All right. And let's see, let's talk about ethics for a minute, because they're going to get ethics out. So lawyer misconduct. And here's something that I had an issue come up one time, and so I was looking at how to handle it. I couldn't tell if something had happened that a lawyer, I couldn't tell if I knew that unethical conduct had happened. And really, I didn't know. To know whether something unethical had happened, I knew I was going to have a hearing and all this kind of thing. So I'm like, what am I going to do about all this stuff? Do I just let this go? Do I have to report it? What do I have to do? So I go looking through the rules of professional conduct, which are rules of professional responsibility, which is Supreme Court Rule 8. Then I look at the rules of judicial conduct, Rule 10. And so you'll see A, B, and C. You got a judge having knowledge that another judge committed a violation of the code. And that will be a judge having knowledge that a lawyer committed a violation of the code. Paragraph C changes it. A judge who receives information indicating a substantial likelihood that another judge has committed a violation of the code. And D, a judge who receives information indicating a substantial likelihood that a lawyer has committed a violation of the rules of professional conduct shall take appropriate action. So what that means is the Board of Professional Responsibility is not the only ethical tribunal that you guys answer to. You answer to me, Judge Peoples, Judge Owens, Chancellor Mansfield, Judge Johnson. Your judges are also ethical enforcement officers if we have information indicating a substantial likelihood that a lawyer has committed a violation. To me, the way I read that is, if I was going to have a hearing, decide for sure, and I think something has happened, then I need to take some action to counsel that lawyer. I can take appropriate action, whatever I deem necessary. Now, if I have knowledge that a violation has happened, I turn it into the BPO. If I know for certain that a violation is taking place, but if I think if something just doesn't smell right, but I just can't tell, then you may get a call from me, or just maybe somebody say, hey, come to my office one day, we need to talk about something. You may get an email saying, I have a concern, I want you to take some ethics courses to get back to it. Let me know once you take 3 hours of ethics on certain topics or something like that. I thought that was interesting. Did anybody already know that? That judges have a duty to police the ethics of the bar, the practice of court. I didn't know that. I thought it was very interesting. And I'll tell you, kind of funny, before I got sworn in, I was talking to Judge People, right, being a judge, I was kind of thinking, this is fine. Lawyers will lie to you. I said, what are you talking about, Judge? He said, they lie. I said, Judge, they're just advocating their position. I could not convince them that y'all are not lying all the time. I don't think they're lying to me. I think they're just being zealous advocates. Okay, that's the label I prefer to attach to all of it. Even though I know most of you lie to me constantly, I prefer to think of them as zealous advocates. Okay, but I will tell you, Judge People think y'all are liars. So anyway, because it was interesting because I thought, well, they're lying. They actually are lying, Judge. You got to do something. But you know what? I was right. That gut feeling was right. The rule 10, Canon 2, Rule 2.15 says that you guys lie to me, I am supposed to do something. But you got to get pretty far before I get to that. Right. So, all right, Andy, go ahead. Next slide. Let's see. Potpourri. So this is just stuff I was throwing in. You guys are probably already aware of all of this. I just want to bring it to your attention because I had this come up while I was practicing. There's a dead man statute. If you have an estate issue and all that, you have action proceeding by or against an executor, administrator, or guardian, in which judgment may be read for or against them. Neither party should be allowed to testify against the other as to any transaction with or statement by the testator, intestate, or ward. It's called and testified thereto by the opposite party. So be aware that you are going to be constrained somewhere in your evidence if you have a deceased living, and your client on the other side is an executor, an administrator, or a guardian. Which would include the guardian ad litem. Merit factors. Okay, let's move to explain this out to me when I was starting. This is another thing that I wasn't necessarily aware of through the statutes and all that. Mostly until something comes up. So not only split up people's assets, I statutorily have to split up their debt, and I have to take these factors into consideration. Purpose, which party encouraged, which party benefited, which party is able to repay. So it's not just you have assets and debts, I have factors that I'm supposed to look at. So I suggest you put up some proof of this if you want debt assigned one or the other. All right, this is kind of about where I was talking about, handling exhibits. So know the rules of evidence. You're gonna try a case, come in, know what hearsay is. Read the rule, and then go find a treatise and read something that explains the rule. All right, you got the Tennessee Law of Evidence treatise, Donald Payne, and all those guys came up with it. Very good resource, gives examples of what we're talking about. Now, most of you guys are probably looking at me and saying, Judge, if you would just open up the evidence book occasionally, then you know I'm right. And I have been right every time you overrule me at every trial. I get it. I understand. I can see the look. All right. But I do try to look at things. I try to get it right. And I try to refresh myself on hearsay. I commend it to you all to read the rules of evidence before a trial. Just skim through them. I mean, the rules of evidence are not that, without the comments, the rules themselves are not that long and unwieldy. So just before you have a trial, go through and look at hearsay. Start at 801 and go all the way through, exceptions, all that kind of thing. It's not criminal evidence if you're not able to that, except when it comes to criminal. So take a look at that. Another thing, refreshing recollection versus past recollection report. I had this come up in a trial once, and one lawyer was objecting to the other lawyer, the procedure they were doing it, and the lawyer trying to get evidence and could not figure out what was going on. All right. So you got refreshing recollection. Mr. Jones, do you remember when X, Y, and Z happened at your farm? Well, no, but I wrote something down on the back of the envelope. Well, if you saw that envelope, did that refresh your recollection? Yeah, I think it did. So you hand the envelope up, let him read it. Said, Mr. Jones, have you had a chance to review that envelope? Yes, sir, I have. Is that the note you're talking about? Yes, sir, it is. Well, hand that back to the bank. That's the key part. Hand that back to the bank. Now, did that refresh your recollection? It sure did. I remember exactly what happened. Now tell us what happened. So that's refreshing recollection. Then you have past recollection reporting. Okay, so Mr. Jones, same thing, handing the envelope. And again, I should have reread the rule, but I'm thinking past recollection reported, that item has to be admissible in the evidence for it to be evidence. I think you can, but the other side gets to look at it and they get to put more things in the record and all that. So there is a procedure for refreshing recollection versus past recollection reported. And if that issue comes up and I don't know what I'm doing, I'm going to take a recess and look at the book. All right. But there are, these things, if you look through the rules of evidence before you start the trial, you'll be sharp and you'll be ready. And you'll know for certain that I'm wrong and I'm wrong. All right. Having exhibits, preparing and protecting your record. Okay. We talked about exhibits earlier. When you have an exhibit, if you pass me a copy, that's not a big deal. I mean, it's fine to do, it's fine to know. The court reporter is going to handle the exhibit. She's going to keep custody of them. I'll have my exhibits laying on the bench if I have any. But whenever you have a court reporter, you're trying a case, okay? If you want to submit a document into evidence or anything else in evidence, what I need to hear from you and to go on that record is, I've shown opposing counsel a copy of this document and now I'm handing it to the witness. Okay? Because the Court of Appeals doesn't know what happened with that exhibit or how it got there. Or I've shown this, or Mr. So-and-so has a copy of this exhibit. It was submitted in our written discussion. And you're giving the opposing counsel a chance to object to that on the record and keeping the record up. So I don't mind letting you guys know during a trial, hey, Mr. Carter, have you shown Mr. Hampton a copy of the document you're about to submit? No, Your Honor, I'll show it to him tonight. I'm doing that for our record, all right? And so if you can get into the habit of saying out loud on the record, I'm showing this to opposing counsel, then the Court of Appeals knows if later on appeal, there's an issue about that exhibit, and the opposing counsel said, I never got that during discovery. I never saw it. First time I saw it was at trial after it had been admitted into evidence. I didn't have a chance to object to it. Then then you got your record made, and that's an issue you want to do. All right. Then another issue on it is bait stamp. All you guys know what I'm talking about when I say bait stamping? It's page number. That's it. It doesn't have to be fancy or anything, but if you've got an exhibit that's that thick, and you're going to start talking about page 7, page 12, page 49, page 80, Mr. Brooks, that's page 5. If you don't have page numbers on there, on every copy that goes out, we're going to sit there and we are all going to number those pages. And we're going to say, I'm going to say, lawyer number 1, you have 86 pages. Oh, you're right, I got 83. Lawyer number 2, how many pages do you have? I got 87. Okay, well, let's go back again. And we're going to sit there and do it. 2 ways. Any of you guys have Adobe Acrobat Pro? Okay. Adobe Acrobat Pro, you can scan, it doesn't matter how many documents it is, scan them in, and there's an option, I don't know what it's called, but you get but page number or something, and it can base stamp them off. It'll label it plaintiff 001 to plaintiff 500, whatever. And everybody that gets a copy of it's got the same song. Or you can take a pencil or a pen and just start writing in the lower right-hand corner. Make sure you get don't skip a page and not stuck together with your coffee or something like that. But that's very helpful, and I don't like doing it. I really don't. And the main reason that I'm doing it, I can sit up there and not even go along and look at this. I may not even have a copy of it, but the Court of Appeals and the record that you leave behind, if this goes up on appeal, if you've got a 500-page document that doesn't have any page numbers on it, nobody's going to be able to tell what document you're talking about. But if you say, Mr. So-and-so, Mr. Jones, turn to page 62 of Exhibit 3. Everybody knows exactly where we are in the Court of Appeals. I'm not trying to embarrass you or be a pain. I'm trying to keep our record clear in case you're in front of the court. All right. I'm almost out of time. I'm gonna back up just one more time. This last thing, because you guys know about offer proof, I'm not gonna go over that. If you don't mind, before you come to a hearing where proof is going to be presented or a trial or anything like that, where witnesses going on stand, please tell them the order of witnesses and examinations and all this kind of thing. What I mean is, Mr. Client, what's going to happen when you get to trial? I'm going to call you as a witness. I'm going to ask you questions. Then Ms. Middlebrooks is going to get to ask you questions. After she asks you questions, I get to come back and redirect you, ask you more questions to clean stuff up. Because invariably, your clients get up there on cross-examination, something will happen, they don't want to, well, yeah, that's right, but and the lawyer doesn't want to say anymore, they got their yes. Well, Your Honor, I want to say something, I got something to say about that. I wish you would tell your clients ahead of time, hey, don't argue with the other lawyer during the cross, just answer their questions, go along with it, because I'm going to then get a chance to come back and clean you up. All right? It just kind of will help smooth out the way the trial goes, and it will lower your client's blood pressure while they're on the stand. That's the benefit to you guys, okay? They're already wound up enough, and then Mr. Hampton or Mr. Carter, somebody gets up there and starts poking on, they want to look at me and say, Judge, bail me out. Hey, ain't my show. All right, so let them know that, hey, I've got your back, okay? Once she gets done with it, I'll have a chance to come clean it up. All right, last thing, I am going to go a couple minutes over because I do want to tell you, skip past that. All right, here's what I'm thinking. When I'm up there in that road, okay, I saw this at a judicial conference. This is the only place you would ever see anything like this, all right? Socrates said, 4 things belong to a judge: to hear courteously, answer wisely, to consider soberly, and to decide impartially. Doesn't that sound great? That's what I'm thinking. This is my job. I get to do this every day, right? I go to the next slide. I'm going to sit down and leave y'all with the reality. I know what you're
Let's see.
With your host, the Reverend Jesse Jackson. contestant number one, what is your name? Larry Slendon. I'm a game tester for Mattel. Oh, how fascinating. Have you tested any interesting games lately? Yes, I have. I just tested a little robot toy. And contestant number two, what is your name?
Martha Rogers.
The truth.
Barbara Wilson.
And contestant number three,
My name is Eleonora.
not important. Tell them what they're playing for. Don Farfado. It's a lovely car. It's a lovely red car. It's a lovely red car with a radio. Back to you, friend. Boy, that sounds good. Larry, why don't you go first? Fine. I'll take astronomy, please.
And the question is, when is the next reappearance of Halley's Comet scheduled?
I know this. It doesn't matter. The question is moot. The White House is locked behind cement barricades. The president confesses he's afraid to go to church because terrorists are after him. The nuclear holocaust machinery is moving into place. As a matter of fact, it's moving into Brooklyn Harbor right now. They're demonstrating down there all night long. The battleship Iowa carrying nuclear warheads arrived today, so we probably won't even live to see Halley's Comet come again. Next question, Barbara.
I'll take miscellaneous, please.
And your question is, what president is on the $100 bill?
Oh,
Sorry, the question is moot. 4 years of the Reagan administration, very few people got to see a $100 bill. More people living in poverty today than there were 4 years ago. But the 35 million living in poverty, 24 million of them are white, 11 million black, Hispanic, and Asian. But no matter whether you're white, black, or brown, hunger hurts. Next question, Eleanor.
excuse me, Reverend Jackson, are we ever going to get to answer a question here?
Under the Reagan administration, answering questions is no longer a priority. One, smile, styles, and profiles. Issues like education, health care, and social programs have to take a back seat to $1 trillion military buildup, a $700 billion tax cut for the rich. As a matter of fact, 90,000 corporations last year made progress and paid no taxes, while people making $2,000 below poverty pay taxes.
Excuse me, Reverend Jackson, aren't these simply your opinions?
Question is moot. Of course, I'm down here on the camera and you're way up there in some glass booth, my monotone friend. Well, I see our time is up.
Oh, who gets the car?
I get the car. Question is moot. Charge. I'm the host, I get the car. If you have any questions, save your breath. They'll probably moot too. You'll just excuse me, I've got to get off my heels and get on my wheels and move on. See you next time on The Question is Moot.